Everybody's ready. Correct me if I'm wrong. We'll do some quick sound checks. I'm going to start with Mr. Braley. Bruce Braley, if you would please give a sound check.
Is it possible to use the main podium or just the podiums here at the council table?
He cannot hear you, Mr. Braley.
You want to turn your mic on?
1, 2, 3, 4, 5, 6.
Yes, thank you. We can now hear you.
Thank you, Counsel.
Thank you. And Ms. Conover, I understand you will be arguing the case and Carrie Thompson will not be arguing but is assisting you. Is that correct?
That is correct, Your Honor.
And Justices, can you hear Ms. Conover?
Yes, thank you very much.
Thank you.
Okay, Ms. Conover, you may begin as appellant.
May it please the court, counsel. Mercy Hospital is requesting that the opinion of the Court of Appeals be reversed and vacated, and the district court rulings in favor of Mercy be reinstated. I'm going to start by addressing the second issue addressed in the Court of Appeals opinion regarding the duty analysis. With the narrow question of whether a hospital has a duty to immediately restrict or suspend a physician's medical staff privileges upon notice of an Iowa Board of Medicine inquiry. I then intend to address the first portion of the Court of Appeals opinion dealing with the issue of summary judgment as to the remaining issues in the case as a whole. With respect to issue number 1, the Court of Appeals held, improperly in our view, that the district court improperly considered foreseeability in its analysis of whether a duty existed under the Restatement Third of torts. Respectfully, we disagree that the district court improperly considered foreseeability. The court's language was part and parcel of the confidentiality analysis of the Board of Medicine regulations and statutory scheme. But regardless of whether foreseeability was or wasn't considered, the Court of Appeals appears to ignore or discount the district court's extensive analysis of the strong policy reasons against finding this duty. This court has repeatedly said since Thompson and the adoption of the Restatement Third that the court has not erased the remaining law of duty. In Thompson, the court noted that when foreseeability is excluded from the duty analysis, there remains the question of whether a principle or strong policy consideration justifies exempting defendants from the duty of reasonable care. In Thompson, the court did not conclude that the analysis simply stops after any discussion about foreseeability. In Thompson, this court contemplated that that policy analysis would be considered regardless of whether the district court reviewed foreseeability or not. In Thompson, while the court ultimately determined there was a duty owed under the circumstances of that case, the court examined those countervailing policy reasons. This court reiterated that position in the Hoyt versus Gutters case as well, noting that the question remained for the court to consider whether there was any policy supporting the no duty determination.
Sorry, I didn't have my mic on. The clock was not started. Thank you. Go ahead, Justice Mansfield.
All right, so here's where I may have a little problem with your argument, Ms. Conover. So, assuming we recognize negligent credentialing in Iowa, that's the duty, isn't it? And then the question is, under what circumstances has the duty to exercise, reasonable care in credentialing been breached? And Mr. Braley came in with an expert, Dr. Pietra Fesa, and why isn't that enough to create a tribal issue for the jury?
And just to be clear, we did not brief, nor was the issue litigated or decided below as to whether Iowa should recognize the tort of negligent credentialing. That issue is first raised by amicus parties, and it's our position the court doesn't need to tackle that issue. It's not been addressed. So there's just really a very narrow question before this court. And just because there's an expert who may say such a duty exists doesn't mean that carries the day if Iowa law says otherwise. And
Though, is the duty to exercise reasonable care in credentialing the physicians that are going to have privileges at this hospital. That's the duty. Then the question is, what's the standard of care? And that's where they brought in an expert. Why isn't that enough?
But the question here, there was no issue as to the initial credentialing of this physician at this hospital. The question here is when the physician became aware of an inquiry
Fair point.
and says he reports it to the hospital, we have no idea when. We have no idea what the nature of the inquiry was. There is nothing in the record fleshing any of that out. Okay, so the plaintiff's position through their expert is the hospital should have immediately suspended the physician's medical staff privileges.
So isn't that a question of, was there a breach? I mean, plaintiff has a burden of showing that not only duty, but breach of duty. It seems to me some of your argument goes to the question of breach. Well, we don't know exactly when. We don't know how much time. You've characterized it as saying, well, immediately suspend his credentials upon getting notice from the Iowa board. All that strikes me as a breach argument rather than duty argument. Am I wrong?
Well, I still go back to the court needs to, Justice Apple, in our view, consider whether there's a public policy reason that says that duty should not exist in the first place. We aren't even to breach yet. The question is, given that the Board of Medicine...
But isn't that just an argument that we shouldn't recognize a negligent credentialing claim? I mean, to Justice Mansfield's point, you haven't contested the existence of the tort. All you're really arguing about is whether or not this conduct was sufficient for the hospital to inquire further. And we're talking about breach. I mean, the duty is the tort, and you've conceded that the tort exists, or at least you're not contesting it in this appeal, right?
You know, negligent credentialing is a very complex issue to tackle. And different states across the country have intentional tort standards versus a negligence standard. Different states across the country have legislative action, others don't. But we don't need to get into all of it. The question is, when we're talking about an investigation that is statutorily confidential, okay, nobody, not even the licensee, knows what's going on. And that confidentiality promotes all kinds of important public policy reasons for the state's Board of Medicine. It enhances the integrity of the Board of Medicine. It allows people to come forward and express complaints that can be investigated. And importantly, what the district court said in this case is it allows the physician to be protected from his or her reputation being marred by the mere fact of an allegation. If we analogize to a criminal matter, we don't presume our criminal defendants guilty, we presume them innocent. And here...
On that point, does the plaintiff's rebuttal disclosure address some of the issues you're raising? As I understand it, what the plaintiff's expert said in the rebuttal disclosure is the case isn't predicated on launching an investigation upon receiving notice IBM is investigating this doctor. It's based on a variety of circumstances, including the history of malpractice litigation against this doctor and this doctor being assigned to CPEP, I guess, and I'm not sure if there's any evidence whether the hospital knew about that, but I'd like you to address that. But I guess it seems like this is more than just, the claim here is more than just launch an investigation upon IBM notice. There are other facts to consider, isn't that what the expert says?
Well, the lawsuit issue, which is kind of part of the first portion of the Court of Appeals ruling, the district court ruled on that secondly. All we know is the fact that lawsuits were filed. We have docket sheets purporting to show that lawsuits were filed. We know nothing about the details of those, and those happened years before this physician was practicing at Mercy. And again, the initial credentialing of this physician was not challenged by this expert. So query whether the fact of those lawsuits, when we know nothing more than that, literally, the
I
record.
agree that if the, at trial, the lawsuits themselves would not be admissible. The mere fact that somebody's been sued, we normally don't admit that. But under Rule 5703, isn't it possible that that could be something that the expert would rely upon in forming his or her opinion?
I don't think 703 elevates otherwise inadmissible evidence that is solely conjecture to the level of something an expert could talk about and rely on. And to be clear, there is literally nothing else in the record about these lawsuits. I mean, the expert didn't come in and say, I've examined these claims, they were factually similar, or there was a finding of negligence. I mean, it's the mere fact of filing. And so to overcome their causation hurdle, plaintiffs have to take the position that the hospital should have immediately suspended the physician.
Or I wonder if you frame the issue too narrowly for us. Why isn't there sort of a middle? You don't have to immediately suspend. That wouldn't be fair to the doctor. But couldn't the hospital have asked the doctor and investigated? And if so, what would have happened?
The doctor, the issue is, though, that we're talking about an inquiry from the Board of Medicine. And we know statistically in front of this court that only 25 physicians of the 600 to 700 a year who are disciplined, or who are investigated, only 25 are disciplined. And so we're going to be suspending physicians to make their to get to their causation point, which is that this physician should not have performed surgery on. They have to take the position that he should have been immediately suspended. Okay, otherwise they're going to fail on their causation element here.
Long ahead of the plaintiff's surgery, was the hospital alerted to the Board of Medicine's inquiry? I didn't see that.
There's nothing in the record answering that question.
Huh, okay.
It could have been 2 days before, 2 years before, we don't know.
Would the doctor, if this case proceeds to trial, would the doctor be on the verdict as a released party?
Well, that's one of the difficult things about a negligent credentialing claim, is that we've got a question of how do we make sure the plaintiff doesn't get a double recovery here? Are we going to compare fault? So is now the hospital obligated to prove up the physician's negligence in order to have that on the verdict form, or does that come in through the plaintiff's proof as one of the elements of the negligent credentialing claim that he is at fault? Somehow that fault has to be compared, or else we do have a double recovery situation.
Or if the jury were to find that, if the doctor's on the verdict form as a released party and the jury finds zero fault there, then is the hospital off the hook?
In a typical negligent credentialing claim, it is our position that the plaintiff has to prove the physician's negligence as an element of their claim. So if there is a question as to the physician's negligence and it's the answer is no, then presumably the instructions don't allow any fault to be assigned to the hospital.
Your briefing is very insistent that we should not address the question there is or there is not a right to sue for negligent credentialing in Iowa. Are you leaving the door open that on remand, if we reverse the summary judgment, you could then pull the trigger on a motion and say don't recognize this court? I'm just wondering why we shouldn't address it now. It's so interrelated. We've got thorough briefing from the amicus parties.
Well, respectfully, Your Honor, although there is some limited briefing in front of the court, we don't have an extensive analysis of how this tort would look in Iowa. We don't have an extensive analysis of what other states' torts regarding this look like and whether they are persuasive at all. And We don't, I mean, we need some briefing about whether this is an issue best left to the legislature, given Iowa's peer review statute and the language in there. Respectfully, even though amicus parties have raised this, again, on the facts of this case, our position is the tort should not move forward because.
Do we even at this point have agreement on the elements of the tort?
I don't know that we do.
Well, if that's true, I guess how do we deal with that on summary judgment? I mean, we're looking at questions of disputed fact that are material, which usually means we have to compare them to some sort of legal standard. It seems like if the elements are disputed, that gives some wiggle room to develop the claim further in the district court.
I don't know that we have any truly disputed facts here. I mean, the district court was pretty clear that he took inferences in favor of the plaintiff. Yes, the plaintiff has an expert, but the question is, are we going to allow a confidential board of medicine inquiry that protects physicians' due process rights to be the basis of a hospital having to do some investigation? And what is that going to do for our hospitals and our medical care around this state? We're going to be summarily suspending physicians, 600 to 700 a year, when the vast majority of them will not have any disciplinary action taken against them. And even when there is disciplinary action, oftentimes it's a citation, it's a warning, it's a fine. Revoking someone's right to practice is a very rare circumstance for our Board of Medicine. I see I'm out of time. Thank you.
Mr. Braley.
May it please the court. I want to start by addressing the concerns raised by Justice Mansfield, Justice McDonald, and Justice Waterman about whether this is timely for the court to consider recognizing the claim of negligent credentialing, because my clients, Roxanne and Tony Rieder, are asking you to do that today. And even though at trial, Mercy took the position that they were assuming but not conceding that the claim exists, assuming and not conceding is contesting. When you do not concede that the cause of action exists, parties in Iowa need clarity. This theory has been up to the court twice. And in the Jenny Edmondson Hospital case, the court laid out the broad framework of the elements of a negligent credentialing case, and we have other cases from other jurisdictions that give us guidance on what that consists of. We know...
But counsel, if I may, the district court didn't really address that issue at all, and typically we let the district court have first crack at it before we would get involved in it.
Well, you're absolutely right, Your Honor, but the district court clearly noted the same thing that I just mentioned, which is that Mercy was taking the position that it was assuming without conceding that the cause of action existed. So the issue was queued up at the district court level, and it's appropriate for the court to consider. It's even more appropriate in this context for the reason that you mentioned, Justice. That is, we should use judicial economy resolving this issue now. It's before the court on a case where we have fully fleshed out facts related to the underlying cause of action. And to allow this case to be remanded and tried and come back up with that issue still unresolved would be a waste of judicial resources when the court has it in front of it now. The other question that was raised by Justice McDonald, that the case isn't predicated on just notifying Mercy Hospital of the investigation, is absolutely correct, Your Honor. In fact, the record is replete with evidence from the executive director of the Iowa Board of Medicine, from a witness at Mercy Hospital in charge of credentialing, and from multiple sources about what Mercy knew and when they knew it. And that is why, in a case like this, you can't engage in duty analysis, which is impermissible, even on public policy grounds, if the stated public policy grounds advocated by Mercy take you right back around to a duty analysis based on weighing that evidence. So even though this is an appellate court, it's important for you all to have a clear understanding of what Mercy knew and what they knew about it. And this is very important because
Let's say that they've mislabeled their argument as a duty argument. And really what they're just saying is the combination of these lawsuits plus the notification of the Board of Medicine. Those two things by themselves are not enough to establish that the hospital needed to go ahead and pull him off patient care.
if that's all there were, Your Honor, that could be correct, but there is far more than that in the record. And you raised a great point about the admissibility of evidence of malpractice suits alone, and that usually arises in the context of a case against a physician, where properly courts exclude simple evidence of the lawsuit alone because it can create an improper inference that the physician was negligent on the occasion in question. But this is a wholly different tort claim. And one of the critical elements mentioned by our experts and identified by the Iowa Board of Medicine, which requires applicants for medical license to submit all documents related to medical malpractice cases when they're applying for a license. That's what Mr. Niebel testified the Iowa Board of Medicine does. All documents, not just judgments, not just settlements. And Dr. Pietrafesa talked about the significance of that in credentialing physicians because it is evidence of a pattern and practice that should be a red flag to the credentialing hospital. It's significant enough the Iowa Board of Medicine considers it an application and that it should be part of the ongoing assessment of competence related to ongoing credentialing.
Mr. Braley?
Yes.
Don't some jurisdictions deal with this prior lawsuit problem by bifurcating the proceedings? So if the physician was still in the case, and I understand this one's not, you would have a trial against the physician on negligence, excluding the prior lawsuits, and then a second tag-along suit that deals with credentialing, where the prior lawsuits could then be admitted without prejudicing the physician, so you wouldn't get that propensity evidence in the second suit.
That's an excellent point, Your Honor, and in fact, that's exactly what happened in this case. The trial judge entered a bifurcation order. The case was settled against Dr. Segal. Then after the case was settled, the underlying issue no longer required a bifurcation, and we were set to go to trial literally on the eve of this summary judgment ruling. And we were pushing the court for a ruling because we had a trial date, we're ready to go to trial, and then the court entered the order, and then we found ourselves on appeal. But one of the other things that's absolutely
I have a record question for you
Yes.
as well. What evidence in the record shows that the hospital knew about the CPEP assignment? And as I understand it, this doctor was assigned for some additional training at some point. Was the hospital aware of that?
There's no direct evidence because of the limited discovery we are allowed in these cases, but there is clearly circumstantial evidence that Dr. Segal was a practicing physician and disappeared to go participate in this program in Denver. We assume that a reasonable jury could conclude that he would have to provide some type of notice to the hospital if he had surgery scheduled or had to make arrangements. But that goes directly to one of the things that the trial judge never discovered that Kent Niebel, the executive director of the Iowa Board of Medicine, pointed out on multiple occasions. So Dr. Segal gets his medical license in April of 2009. The board opens its first complaint file against him in 2011. They open their second complaint file against him in 2012. In 2012, he goes to the Center for Personalized Investigation because the board had concerns about his clinical competency. And they send only 8 doctors a year and consider it to be relatively rare, which shows you the level of concern the board had in 2012. In 2013, they opened their 3rd, 4th, and 5th complaint files, and Dr. Segal admitted that through the years being plural, he received notice of inquiries from the board looking into his competency and informed Mercy that he was under investigation by the board before he ever performed surgery on Roxanne Rieder. So that's the state of what he told Mercy. But it's important to look at what Kent Niebel said Mercy would have known even before Dr. Segal was contacted about the investigation. He said that the Board of Medicine counts on hospitals like Mercy to provide the requested documentation during an investigation. And that documentation, he said, when you have a problem physician with multiple complaints over multiple years, which is what Dr. Segal had, they not only request patient files, they request the surgical complication rate for that individual surgeon, and they request the credential file for that specific surgeon, and they do it with a subpoena that identifies what they're asking for, in this case, the surgeon by name. You can't get a surgeon's credential files unless they're identified by name. You can't get their complication rates unless they're identified by name. And Kent Niebel said that they would reach out and gather that information, especially in a serious investigation like this one, because they want to be prepared before they even contact a physician. So they're armed with all of that knowledge, and the hospital is on notice long before the physician even finds out. So Mercy is claiming this public policy argument that the peer review process had just begun when Dr. Segal was notified of these gross malpractice claims the day my client was discharged from the hospital. And in fact, Mercy, based on this overwhelming circumstantial evidence, had extensive knowledge that Dr. Segal was being investigated in the 4 years leading up to her surgery and did nothing. That evidence is undisputed.
Counsel, what do you make of the argument, though, that what you're talking about are allegations or investigations, and the district court relied on this public policy that, noting the statistics that there's 600 or 700 of these investigations every year, and that only a small percentage of them actually turn out to be anything. And as I understand it, relied on that as sort of setting the public policy of, based on the relatively small number of investigations that actually, I guess, turn out to involve merit, or at least involve some sort of discipline, he wasn't going to impose a duty based on that. What's your response to that?
Well, Justice McDermott, the Court of Appeals criticized the trial court for engaging in public policy analysis under the line of cases that's saying it's not proper for the court to do that, especially when it goes to the foreseeability issue that the jury is supposed to decide, which is what this whole summary judgment challenge is all about. Because the facts that I laid out for you present overwhelming evidence, along with the important public policy consideration of protecting patient safety, that every hospital I know of in the state claims to be its most important consideration. And when the trial judge came back to public policy analysis after recognizing this issue about duty analysis under Restatement Third, it came right back into weighing and balancing a public policy consideration that only took into account the peer review privilege, which in the Minnesota case recognizing negligent credentialing, the court there balanced the two interests: recognizing a claim for negligent credentialing, protecting the statutory peer review privilege, which is almost identical to Iowa, and the Minnesota Supreme Court said those interests can be harmonized by recognizing negligent credentialing, and that's why we are asking this court to not only recognize negligent credentialing for the first time formally and officially, but also remand this case for trial on the merits. It is important not only to Roxanne and Tony Rieder that you do that, but it's important to thousands of Iowans who are patients at hospitals in this state and go into those hospitals assuming that the hospital is only privileging physicians who are competent to provide the care that they assume they're going to get.
Mr. Braley, I have a question.
Yes.
Ms. Conover made a comment, the initial credentialing has not been challenged by the expert. And then you went through a litany of all of these license challenges, starting in 2009 when he got his license, then in 11 and 12, and then he went to took place in Denver, and then and then in 13 he had third, fourth, and fifth. Wouldn't all of those things, or the lion's share of those, have happened before he was hired at Mercy?
No. No, Your Honor.
Timing.
He was hired in 2009. He testified in his deposition he moved here because his wife had family in Iowa. So he applied for his medical license, got it in April of 2009. The things you're describing, Your Honor, were complaints filed with the board 2, 3, and 4 years later. And then my client was injured in 2015. So there's a substantial period of time. And you raise an excellent question, and that is, it used to be in these cases that the initial credentialing was the critical decision for the purpose of determining liability. But as medicine is involved and as credentialing has evolved, we've seen a move toward a continuous credentialing process where physicians are put on notice that if things come up in their background or changes happen in their competence or their health, they have an ongoing duty to inform the hospital on something that could affect the hospital's legal duty when it comes to credentialing. And so it's not just this static period, was he qualified in 2009, but it's something the hospital must continuously evaluate as he practices medicine at their hospital. And as was,
Counsel, how, over here, sorry.
sorry.
That's all right. So how does the confidentiality of those records come into play? How do we know that Mercy's hands are tied if they can't tell us that they did, in fact, do the things that you're suggesting that they should have done, but those records are all confidential? And so I think the district court talked about that there wasn't a sword and a shield because that confidentiality applies to both sides.
That's a great point, Your Honor, and that is, in fact, the reality. It is an accepted fact of life in negligent credentialing cases that both the plaintiff and the defendant could be penalized by the confidential protection given to certain activities that occur in a hospital setting or at the board setting. But the plaintiffs are also penalized in this case by being precluded from doing the type of normal discovery you would do. So let's take the example not of a hospital employer, but a
You can wrap up.
Oh, I'm sorry,
That's okay.
truck driving employer. You have a driver qualification file. You have people who made hiring decisions. They are available for their depositions and subject to discovery. So the plaintiff is being penalized just as the defendant is, and that's part of the balancing that goes on in these cases. Thank you for your time.
Excuse me, Chief Justice, can I ask one more question? Mr. Braley, can you give me the public policy case for recognizing the tort and why it adds anything of value above and beyond the tort directly against the physician?
Yes, Your Honor, in the Minnesota Supreme Court case cited in our brief, and in a host of the 30 other cases where appellate courts have recognized the tort of negligent credentialing, going back to the Illinois Supreme Court in 1965, they talk about the public policy that is designed to be protected, and that is to make sure that patients who receive care in a hospital setting, that their patient safety is an important consideration when hospitals decide who to credential to practice in their facility. As was noted in the amicus brief filed by the Iowa Association for Justice and in our brief responding to the AMA, one of the things that hospitals have is superior knowledge because of their access to the National Practitioners Data Bank. They have a lot more information on whether a doctor's been sued, whether they've settled cases, whether they've had judgments entered against them, whether they've had disciplinary action than the general public who comes into that hospital as a patient. And that is why we expect them to do more than just say it's not our problem when they are on notice of specific concerns about a specific physician they have credentialed.
Thank you, Mr. Braley. Ms. Conover?
All right. what counsel talked about in terms of investigations being opened by the Board of Medicine in 2011, 12, subsequent years, none of that information was public until May 15, 2015, the day this patient was discharged from the hospital. What counsel is talking about in terms of the ability of the Board of Medicine to subpoena records, subpoena complication rates, subpoena credentialing files, that was discussed in the context of what information the board can gather. There is simply no evidence that can be accessed in this case as to what information the Board of Medicine did gather in this case or what was in Mercy's credentialing file. We are prevented from defending against claims of innuendo and conjecture by presenting our very best evidence, which is what's in our credentialing file. So make no mistake, there's no evidence in this record that Mercy was aware of investigations going on in those years. With respect to the evaluation in Denver, the only evidence in this record is an affidavit from Dr. Segal. In what context, it's unclear that it was made, that he was sent for an evaluation and that it was favorable to him. There is no evidence that Mercy was made aware of that evaluation. What counsel suggests that a surgeon just disappears, so the hospital must know, is purely speculation and conjecture. Physicians practice medicine in places other than the operating room, and the physician could have been taking his vacation time to go do the evaluation. But in any event, the only inference that could legitimately be derived from that affidavit was that the evaluation was favorable to him. And keep in mind that the Board of Medicine has statutory powers to summarily suspend a physician if they deem that individual a threat to patients, if patient safety is at issue. And because the board's investigative file is confidential to everybody, except to the licensee only after the licensee is formally charged and decides to contest those charges, the Board of Medicine is really in the best position to know whether a physician's license should be summarily suspended.
Counsel, of the 30 states that have recognized the tort, 30 or so, have any of them retreated and then de-recognized, saying this is causing problems, we're losing doctors in rural areas, or anything like that, or has life gone on?
Your Honor, that is an issue briefly set forth in the amicus position from the Iowa Hospital Association, Iowa Medical Society. And in the state of Kentucky, I'm aware that the Kentucky courts there indicated it's a very rural state, and that plaintiffs are, in not recognizing negligent credentialing, the court there said plaintiffs have the ability to bring negligence claims against their providers, and that is adequate remedy enough without going forward. And there's some other states in Texas and Arkansas which set forth policy reasons against recognizing the tort as it exists in some other states. So again, that gets to the issue that this is a really nuanced and complex analysis. And you know, our legislature has spoken about peer review records and the confidentiality of those and the immunity provided to those who participate in the peer review process, and recognizing this tort and imposing this duty that we see as a narrow question before this court really contravenes what the legislature envisioned in setting forth those peer review privileges and protections. And then finally,
again, it seems like the question is so interrelated that what do we do with this summary judgment? We almost have to decide, is this a tort or not? What are the contours? But let me ask a practical question. If the summary judgment's reversed and there was a bifurcation order, at trial, would the jury first consider the negligence of the release party, Dr. Segal, before it then went on to address evidence regarding negligent credentialing?
The bifurcation order in this case applied specifically, I think, to the discovery, process, and that could be imposed in a case, I suppose. We view the plaintiff as having the burden to prove the physician's negligence if the negligent credentialing case is going to go forward. But plaintiffs take the position that, all the evidence needs to come in. And frankly, this idea that we can just bifurcate out the lawsuits, I think this was a conversation with Justice McDonald, as to the physician. I don't know how the hospital's in any different position if all we know is the mere fact of filing a lawsuit. That is all we know on this record. And so how the hospital can recover from the improper inference created by the implication that this physician must have propensity to act negligently, and therefore this hospital should not have him have privileges at their hospital, I fail to see a meaningful distinction there. I see my time has expired.
Just to clarify, it's still your position, is it not, that the question of whether or not we should recognize the tort is not before the court, that you have not briefed it, your client has not raised the issue, the district court didn't decide it. Have you changed that view today, or is that still your position?
That is still our position, and it's consistent with Hall versus Jenny Edmondson, footnote 4 in that case, Your Honor. Thank you.
Thank you. The case of Rieder versus Segal et al. Is hereby submitted. The final case of Costaglanis versus Yates is submitted without oral argument. Court will be adjourned, and the bailiff may close court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.